topic is for tonight. And religious freedom is a founding principle in the establishment of this country, something that is all too often taken for granted. And it should be of great concern for Catholics today. In the post-war era, from the dissenting opinion in Everson versus the Board of Education, 1947, which seemed to be the jumping-off point for the misinterpretation of the phrase separation of church and state, to more modern issues, like U.S. Senators Sanders, Feinstein, and Durbin exhibiting a belief that strong Christian or Catholic conviction disqualifies one from holding public office, the stakes have never been higher. Where is that increasingly ambiguous line that we, as a country, use to separate freedom of religion and freedom from religion? Perhaps our guest tonight can offer some clarity. Matthew Franck is the director of the Simon Center on Religion and the Constitution at the Witherspoon Institute in Princeton. He is also professor emeritus of political science at Radford University in Virginia, where he taught for 21 years, and is a visiting lecturer in politics at Princeton University. His work has appeared in various scholarly books and journals and in popular publications such as the Washington Post, First Things, and National Review magazines, and the Witherspoon Institute's Public Discourse website. We are honored to have him with us here tonight. Please help me to welcome Dr. Matthew Franck.
Thanks so much. Appreciate it. Thanks for that. Thanks for that fine welcome. I want to thank Betsy Solon and Father Michael McLean, our pastor, for making this event possible and for inviting me to come. My wife and I are parishioners here at St. Greg's. If we're not familiar to you, because we're 10:30 people and maybe you're 9 o'clock. I don't know, but it's a big parish. It's easy not to know people. So in keeping with Betsy's request, I've got about a 40-minute talk, and then there should be ample time for Q&A. If the talk sounds a little formal, it's because I have written it out as a complete text. I'm actually hoping Father Jay might help me with this, with prayer and encouragement. I'm hoping to see it perhaps in Columbia Magazine, the magazine of the Knights of Columbus. But here goes. On Wednesday, September 6th, an event occurred in Washington to which Ed already alluded. The Senate Judiciary Committee held a hearing in which the senators publicly interviewed two women nominated to federal judgeships: Justice Joan Larson of the Michigan Supreme Court, nominated to the federal Sixth Circuit Court of Appeals, and Professor Amy Coney Barrett of Notre Dame Law School, nominated to the Seventh Circuit. President Trump has been taking the advice of conservative legal experts at the Federalist Society when making his judicial nominations. That's how we got Justice Neil Gorsuch. And this has Democratic senators very worried. The two women who testified on September 6th are both highly accomplished, with well-earned reputations as legal thinkers, who are devoted to what's called an originalist reading of the Constitution, meaning that they strive to understand its terms as they were understood by those who wrote and ratified the document. And they oppose manipulating the law to conform to a living Constitution that means something new from one age to the next. This means that the Senate Democrats are very worried. Their party has achieved some of its most treasured policy goals, such as legalized abortion and the imposition of same-sex marriage, as a result of judicial decisions, rather than democratic choices by representative institutions. And so they come into these hearings very concerned that these policy gains could be threatened by judges who might overturn those decisions. They who live by judicial activism may die by judicial reversal of that activism. So they're inclined toward hostile questioning of such nominees, even when they would sit on lower courts, where the judges are ethically obliged to follow Supreme Court precedents, even when they think they're mistaken. One reason to worry is, if you're a Democrat that is that some of these appeals court judges, if they make their mark in notable ways, are likely to be on the short list in just a few years for the next available Supreme Court nomination. And there they would be free to overturn those precedents that bound them on the lower courts if they thought they were mistaken and an appropriate case arose. However, and this is where it gets interesting, senators feel constrained and have felt constrained for a long, long time, for better or worse, by a kind of informal constitutional norm that says that it isn't right to ask a judicial nominee how she would vote on, or even what she honestly thinks of, any of the existing precedents that the Supreme Court has set on the meaning of the Constitution. Any nominee who would answer such a question is said to be prejudging a future case that might arrive at her court. So the nominees always refuse to answer, and the senators have accepted this and largely stopped asking that kind of question. So with Judge Larson, the Michigan Supreme Court Justice, who was at the table on September 6th, the senators really couldn't do much more than dance around the issue of what she thinks about various controversial decisions of the past. But Professor Barrett gave the Democratic senators an opportunity to attack her from another angle. She didn't know she'd given them that opportunity, but here's what happened. First of all, she's known, Professor Barrett, from public speaking opportunities that she's taken. She's known as a devoted, faithful, and outspoken Catholic, a mother of 7, whose scholarship and public speaking has considered legal issues from the standpoint of her Catholic faith. In 1998, when she was still a law student at Notre Dame, where she now teaches, she co-authored an article with one of her law professors, who's now John Garvey, who is now the president of Catholic University of America in Washington, but was then at Notre Dame. And together, Garvey and Amy Coney, as she then was, she wasn't married yet, they pondered what obligation a Catholic judge might have if his faith leads him to oppose the death penalty, but his duty under the law is to sentence someone to death, to that punishment. Their conclusion was that a judge in that situation must not, twist the law to conform to his religious opposition to capital punishment. But if he himself has a firm ethical position against it, he must therefore recuse himself, passing the case to another judge to impose the sentence. If you read the Law Review article, and I have, it's clear enough what their argument is. And it should be uncontroversial, because they found a way in this argument for a judge to follow both his conscience and the requirements of the law. But the Democratic senators, led by ranking member of the Judiciary Committee Dianne Feinstein of California, either did not understand her view in this article or decided to distort it for political purposes. I can't read hearts, so I don't know which. Senators Klobuchar and Franck, both of Minnesota, Hirono of Hawaii, Durbin of Illinois, Blumenthal of Connecticut, all took shots at Professor Barrett, each one insinuating in some way that her devout Catholic faith would lead her away from impartial judging. By which what they really meant, here I'm not reading minds or hearts, I'm listening to what they said. What they really meant was that they worried she would one day vote, if she got in the Supreme Court, to overturn Roe versus Wade or the same-sex marriage ruling Obergefell versus Hodges from 2 years ago. Senator Durbin, observing that in her article she and her co-author had referred to judges who were faithful to the Church's teaching as, their phrase now, Orthodox Catholics, asked her if she considered herself one. Professor Barrett wisely sidestepped that one with very becoming modesty, I must say. It was adroitly done. But it was Senator Feinstein, in a second round of questioning, who uttered the most memorable line of the day, saying that there must be a difference between law and dogma, religious dogma. And she told Professor Barrett that from where she sat, the senator, it seemed, quote, "the dogma lives loudly within you," end quote, and that this was cause of concern of some kind. What Durbin and Feinstein both were trying to do with the Orthodox Catholic question and the dogma statement, they were trying to find something to pin on a nominee who they suspected might one day participate in undoing the decisions that they're intent on defending. decisions the American people would never have made themselves, but which were imposed on them by judges. But feeling constrained by that norm I mentioned earlier, oh, you mustn't ask directly about what people think of Supreme Court precedents, they stumbled across another boundary senators must not cross. They had suggested that they wished to impose a religious test on judicial nominees, a test that would rule out Orthodox Catholics who regard the unborn as precious human beings and marriage as a sacred bond between a man and a woman. Now, where does this norm show up? No religious test. Well, in the original Constitution, before any amendments were added, including the first, before the framers even agreed that any amendments were necessary, in the original Constitution there is already a clause that forbids a religious test. Immediately after committing every public official to take an oath to the U.S. Constitution, Article 6 of that Constitution says, quote, "But no religious test shall ever be required as a qualification to any office or public trust under the United States." Now, technically, this only forbids, if you read it narrowly, this only forbids Congress to attach a religious test to the formal qualifications for office. Imagine, Congress passing a law, creating an office, and saying, judges of the courts of appeals may not be Catholic. If they actually put that in the law, that would be the kind of explicit and formal religious test that this clause of the Constitution is supposed to forestall. But if the letter of the law might not capture exactly what Feinstein and Durbin did, certainly the spirit does. They appear to be suggesting that the mere fact that Professor Barrett is an openly devout Catholic is a reason for senators to vote to defeat her nomination. And this is pretty clearly exactly the kind of thing the Constitution condemns as an unjustifiable ground on which to deny someone's fitness for office. So how did we get to this place in our political life? When several senators, one of them Durbin, a professed Catholic himself, should suggest that a distinguished law professor deserves to be kept off the federal bench because she is suspected of being too faithfully Catholic. As I've already suggested, part of the explanation lies in the liberal secularist reliance over the last several decades on the courts to achieve policy results that most of the American people and their elected representatives would never vote to adopt. Activist judges gave this country the most liberal abortion laws on the planet. Activist judges then imposed same-sex marriage 2 years ago on a country that was by no means ready to adopt that revolutionary change by its own choice. And who stands against those injustices? Catholics do. But not us alone. Also Orthodox Jews, devout Muslims, faithful Mormons, evangelical and Pentecostal and creedal Protestant Christians of all sorts. The so-called culture wars over these issues have pitted people of traditional faith on one side against secularists on the other. Now, the secularists are sometimes joined by people in the more liberalized, I would say more attenuated, more falling away from their traditions, religious communities. But it's the secularists who call the tune. And because in the U.S. people of strong faith are still a force to be reckoned with at the polls on election day, the secularists and their liberal religious allies are inclined to turn to judges and bureaucrats to achieve their objectives. So, to turn to another example, this one not judges but bureaucrats. The so-called HHS mandate, a rule requiring employers to provide no-cost contraceptives, abortifacients, and sterilization procedures to women in their employee health plans. That mandate was not written into the Obamacare statute by Congress in 2010, even though all the votes for Obamacare in 2010 were cast by Democrats. Even when they managed to do that, they didn't have the nerve to put that mandate in the statute. No, it was fashioned a year later, 2011, by bureaucrats, administrators in the Department of Health and Human Services as a so-called implementation of what the law said in one of its provisions on preventive care. So they simply shoehorned all of that into the preventive care mandate and said, you got to do it. You offer insurance to your employees, you got to provide this. It was this mandate, finally put in place despite many objections to it on multiple grounds in early 2012, that prompted our bishops to create their Committee on Religious Liberty, headed by the Supreme Chaplain of the Knights of Columbus, Archbishop William Laurie of Baltimore. It was also at this time that the bishops created the annual Fortnight for Freedom, a 2-week period for education and prayer in defense of religious freedom, which stretches from the feast day of Saints Thomas More and John Fisher in June to the 4th of July. Nice bookends. The Obama years, with events like that, ratcheted up the conflicts in our society over religious freedom and the place of religion and in public life. It was during these years that we began to hear leading politicians pay their respect to freedom of worship, a phrase that suggested they would like to pare back full religious freedom and minimize it, leaving only the core freedom to believe and worship in private, in our homes and in our churches, our synagogues, our mosques. Religious freedom in full, in contrast to mere freedom of worship, includes our freedom to act on our religious faith outside our home, outside our churches, to act on our belief, our conscience, in the public square, in our civic interactions, in our commercial interactions with other people. It also includes the right of religious institutions, organizations, enterprises, and persons to maintain their autonomy and integrity in the face of demands that they conform to public policies that would compromise that integrity. It's precisely this religious freedom in full that has been increasingly under attack in recent years. Fortunately, I have some good news for you tonight. We've seen significant victories for religious freedom and for religion's place in public life, and the Supreme Court has been responsible for much of the good news here. Credit where credit is due. We can thank, in large part, judges like Chief Justice John Roberts, Justice Samuel Alito of Hamilton, New Jersey. The two of them joined the court in late 2005 and early 2006, respectively, and doubled the voting power of Justices Clarence Thomas and the late Antonin Scalia. And based on what we've seen so far, I believe we have reason to expect very good things as well of Justice Neil Gorsuch, who was appointed to succeed Scalia. So let me run down 5 or so examples of successes for religious freedom that these judges have been responsible for. In 2011, the Supreme Court held that an Arizona law that gave taxpayers a tax credit for contributions they made to charitable organizations providing tuition scholarships to students attending private schools, including religious schools, that law could not be challenged by other Arizona taxpayers who didn't want to take advantage of it, but also wanted no one else to be able to. Wanted the tax credit invalidated as a so-called establishment of religion. This should have, I mean, if you think about it, this should have been a no-brainer, an easy case, but it was close. It was 5-4. A year later, in 2012, the court held, this time unanimously, that federal discrimination laws can't be applied constitutionally to the employment practices of religious institutions where those practices concern people working in a ministerial capacity. This so-called ministerial exception had been recognized by several lower federal courts for decades, but this was the first Supreme Court case squarely addressing it. And amazingly, despite that history, the Obama administration argued in the Supreme Court against any recognition of any such exception. And they lost 9-0. The exception was honored in a resounding rebuke to the Obama administration. 2 years after that, 2014, the court decided that the town council of a small rural community in upstate New York, a town called Greece, near, I believe it's near Rochester, the court decided that the Greece town council did not violate the Establishment Clause when it invited local ministers to pray at the beginning of council meetings in public session, open public session. Even though nearly all the ministers who showed up in response to this invitation were Christian ministers who prayed openly in Jesus' name. This was a close case again, 5-4. And there continue to be similar cases litigated elsewhere in the country. Most recently, there was one in North Carolina. A year after that, a unanimous court decided, not under the First Amendment, but under a federal statute, an act of Congress protecting the religious freedom of prison inmates, that a Muslim prisoner in an Arkansas penitentiary was entitled to grow a half-inch long beard as an expression of his religious belief, since a beard that short posed no security risk to fellow inmates or to prison personnel. I think this is more than a half an inch, and I don't know where I would hide a weapon. Also that year, in 2015, the court decided unanimously that a town in Arizona could not impose a signage rule on churches that imposed a strict limit on the size, the number, the location, the time of display of temporary signs directing worshipers and other interested persons to the location of their churches. The kind of stuff you go to an intersection and stick in the ground, this way to St. Greg's, right? The case was decided mostly on freedom of speech grounds, since it would affect anyone posting temporary signs giving directions to an event. But churches were the distinct beneficiaries, as the most frequent posters of such signs along roads and intersections. Finally, just this past June, 2017, the court decided a very significant case, striking down the application of a state Blaine amendment. I can explain why they're called Blaine amendments in Q&A if anyone wants to know. But these amendments, which are common across many state constitutions, prohibit the disbursement of state funds for any purpose to a house of worship or other religious institution. But the case concerned a Lutheran church in Columbia, Missouri, that ran a daycare center. And all the church wanted to do was to apply for a state aid program that helps such daycare centers resurface their playgrounds to make a more kid-friendly, cushiony surface that's made from recycled automobile tires that otherwise just fill up landfills. That decision was 7-2. The surprise for me reading the case, and I've been reading Supreme Court cases for over 30 years, so it takes a lot to surprise me, was that the dissent by Justice Sonia Sotomayor, who was joined only by Justice Ruth Bader Ginsburg, amazingly asserted not only was Missouri entitled to freeze out a church-related daycare center when all other daycare centers were qualified to apply, but they were required to freeze them out by the Establishment Clause of the First Amendment. That was the Sotomayor argument. Now, so far I've let out the cases concerning something I mentioned earlier, the HHS mandate, and I want to turn to them now. Those cases have been based not on the religion clauses of the First Amendment, but instead on something called the Religious Freedom Restoration Act, a 1993 federal law that permits religious objectors to a legal requirement to seek an exemption from that requirement from a federal court. In this way, the requirement would be left in place for others, but they would be exempted, honoring their conscientious objection to it. The burden would be lifted from them alone. Now, a lot of states have similar laws. State RFRAs, RFRA, Religious Freedom Restoration Act, often called RFRAs by those of us who get tired of saying Religious Freedom Restoration Act. these statutory protections for religious liberty are a relatively recent phenomenon, the last quarter century or so. Many legislatures have seen them as necessary ever since the Supreme Court decided a 1990 case that largely abandoned a previous pattern of decisions in which the court made exemptions based on the First Amendment. They said, we're not doing that anymore. That's not really a sensible way to read the First Amendment. And legislature said, but you know what? We liked that. So we're going to ask you to do it anyway under these statutes that legislatures pass. So we've got this patchwork quilt. Some states have these laws, some states don't. But the federal government has a law that governs all federal policymaking, including what the whole executive branch does. So when the HHS mandate was imposed on employers under Obamacare starting in 2012, this prompted a wave of exemption-seeking lawsuits to be filed in federal courts beginning that year, all across the country. The first ones that made it all the way to the Supreme Court were the suits filed by Hobby Lobby, the craft store chain, in the courts of the 10th Circuit out west. And a companion case was filed by an Amish or Mennonite employer in Pennsylvania that makes furniture called Conestoga Wood Products. So that they were in the Third Circuit. The court decided the two cases together, and Hobby Lobby was listed first, so it's called the Hobby Lobby case. The court held in that case in 2014, that family-owned business corporations could claim the protection of RFRA, the Religious Freedom Restoration Act, that the HHS mandate requirement imposed a substantial burden on the freedom of conscience of those businesses and their owners, and that because the government could have found a less burdensome way to achieve its object than imposing this burden, an exemption had to be granted. That was a close one. It was 5-4, and it still remains very controversial on the secularist left, which objects entirely to the idea of corporations claiming religious freedom, even when corporations actually are the way people do business with one another. But here's what's really amazing, and I'm not sure it's appreciated quite as much as it should be. The Obama administration persisted even after the Hobby Lobby ruling in trying to enforce the mandate against other challengers whose claim for an exemption was even stronger, like the Little Sisters of the Poor, whose case to this day has still not been settled. I don't know if you knew that. The Little Sisters and similar religious organizations, not commercial corporations, but religious organizations who employ people, they were offered a so-called accommodation by the Obama administration, which, not to put too fine a point on it, consisted of their pretending that they really weren't responsible for the contraceptive insurance coverage when they still were. And so they couldn't accept it. The Little Sisters flatly refused this accommodation. Well, after the much lamented sudden death of Justice Scalia in February 2016, the court, now teetering in perfect balance, I think, between 4 justices who would have sided with the Little Sisters and 4 who wouldn't, they kicked the Little Sisters case back down to the lower courts with some vague guidance that something should be worked out down there. And it hasn't happened. For the remainder of the Obama administration, until January 20th of this year, the Obama administration was stubbornly refusing to sort of meet the Little Sisters and work this out. And to my amazement, we're 8 months into the Trump administration, and no relief has come from that executive branch either. Not yet. At least the good news is that in the meantime, the Little Sisters are not paying a fine, and they're not being forced to violate their consciences. Well, that was all my good news. So now for the worrisome stuff. We've done the good and now the bad. We'll get to the anxious. On the negative side, we have fewer examples, but they should concern us. In 2010, the Supreme Court ruled 5-4 that a student chapter of an organization called the Christian Legal Society which was seeking recognition as a student group at the Hastings College of Law in San Francisco. Hastings is a standalone institution, but it's part of the University of California, so it's public. The court decided that Christian Legal Society could be denied the status of a registered student organization because its charter obligated students who joined the group, let alone its officers, to affirm their belief in Christian moral teachings, including those teachings that concern sexual relations. This the law regarded as discrimination against those who hold a different view. And they implausibly claimed at first at the law school that the Christian Legal Society's discrimination, if the group was recognized by the school, would imply that the school was discriminating. Who would make that mistake? That looked like a loser of an argument for the law school, so in mid-litigation, like right in the middle of it all, they changed their policy and said, no. What our policy really is that all student groups must accept all comers who approach them for membership. It's absurd. They don't actually apply that even-handedly to all organizations. They don't demand that the college Republicans let Democrats in, or that the chess club consent to be invaded by backgammon players who changed it to the backgammon club. Okay. So it was clear that the school did not enforce this accept all comers policy across the board for all student organizations. But this maneuver gave the school the cover it needed in the Supreme Court, and the school won 5-4. Justice Alito, the hero of Hamilton, in dissent, pointed out that under either version of the school's group recognition policy, religious organizations that insist on a common belief among their members would now be vulnerable to being frozen out of campus life at any public university that wanted to follow the lead of Hastings College of Law, let alone private universities. Now, I should say that wave of ostracism has not happened. There are a few isolated and notorious examples, like the private Vanderbilt University in Nashville. But thank goodness that precedent has not done as much damage as it might. Earlier this year, and there are cases that the court decides not to review, and they can be interesting too. Earlier in 2010, the court declined to hear the case of a public high school's wind ensemble in California that was told it could choose any piece of music from its repertoire to play at graduation. The wind ensemble voted to play an instrumental version of a piece of music familiar to us in this parish, Franz Bebel's Ave Maria. Now, did you notice it was an instrumental version? They weren't actually going to sing the Latin text of Ave Maria. The wind ensemble was going to play an instrumental transcription arrangement of it. But because the name Ave Maria would appear in the program, people would freak out, apparently. So the school authorities said, no. Our policy actually is that you can only choose music, their words, of a secular nature. You can't play Ave Maria at graduation, even though they had learned it as part of their repertoire under their music director. Only Justice Alito publicly dissented from the court's refusal to take this case. For him, it was obvious religious viewpoint discrimination. And as he pointed out, there are now 10 million high school students in the states covered by the Ninth Circuit who can be told by their school principals that they should refrain from any religious expression, even musical, instrumental religious expression, at official school functions. One last bit of bad news, and this is another case that was declined. In June 2016, after the death of Justice Scalia, the court declined to hear a case, again from the Ninth Circuit, in which that lower court upheld a Washington state regulation requiring all pharmacies to stock and dispense so-called emergency contraceptives, like Ella and Plan B. These are known to the FDA as potentially, in some cases, causing a very early stage abortion. Well, there's a small chain of pharmacies owned by the Stormans family in Washington state. They're Christians. They opposed dispensing such products. They were perfectly willing to refer customers to other nearby pharmacies, 5 minutes, 10 minutes away. But Washington would not relent. You must carry these products for patients or go out of business. And the courts ruled in favor of the state regulators, and the Supreme Court refused to hear the case. It takes 4 votes for the Supreme Court, 4 of the 9 justices, to put a case on the Supreme Court's docket and review it. Justice Scalia had passed away. He probably would have been the 4th vote to review it. Then they would have, if they were sympathetic to the Stormans family, they might have tried to persuade one more vote to come on board after arguments. But it was not to be. Justice Alito again wrote the dissent, and this time was joined by Roberts and Thomas after Scalia's death. And he pointed out that this policy was pretty clearly fashioned to target these business owners because various exceptions were made to this requirement that the drugs be available, except no exception was made for religious or moral objections. Now, I've just marched through a lot of examples. What's the pattern? Each of these examples, including the good news ones, some of which were close votes, suggests that a secularist elite is intent on treating people of faith as outsiders in American society, on the fringe, subject to silencing or discrimination against their point of view, in business, in education, in public life, generally. And that brings me to the final category, the anxious category, involving the latest form of elite hostility to religious freedom, to which the Supreme Court has contributed itself, if unintentionally. In June 2015, when the court decided 5-4 to impose same-sex marriage on the whole country, the dissenters in the case worried out loud that the ruling would have significant fallout for religious freedom, even though that issue was not a legal issue in the case as such. Justice Kennedy, who had written for the 5-justice majority, reassured his readers that, in his phrase, decent and honorable people have religious reasons for believing that marriage can only be between a man and a woman. And Kennedy went on to say that they could, of course, continue to believe that and say that and teach their children that. Yeah, sure, said the dissenters, but will they be allowed to do more than whisper it in their homes, in private? Will they be able to act on that belief as the free exercise of religion implies, in the public square, in commerce? Will they have more than just freedom of belief, freedom of worship, but religious freedom in full? We're finding out now that if the partisans of the marriage revolution have their way, the answer to that question is going to be no. In several states, we're learning that if you dissent from the new normal on marriage, you can be accused of sexual orientation discrimination under state law. Some states have that as a category of forbidden discrimination, discrimination on the basis of sexual orientation. Not all states do, and there's no such federal law yet. But particularly vulnerable here are the small businesses that cater to the wedding trade. Christian business owners who make floral arrangements or take photographs or create custom cakes for weddings are under fire, risking their livelihoods by standing up against demands that they compromise their consciences by lending their creative talents to same-sex wedding ceremonies. So far, every such case involving a state versus a wedding vendor has gone the state's way. But now the Supreme Court has agreed to hear the case of Jack Phillips, the owner of a shop called Masterpiece Cake Shop in Colorado. Phillips was approached a few years ago by a gay couple who asked him to do their wedding cake. As a Christian, he politely declined, saying that they could buy any other pre-baked item in the store. And furthermore, he said he would happily do custom work for them for any other occasion, like birthdays. But his religious beliefs about the nature of marriage meant it was impossible for him to do their wedding cake. Colorado has one of those laws against discrimination on the basis of sexual orientation. And it's enforced by a state human rights commission. Now, it's obvious that Jack Phillips did not discriminate on the basis of sexual orientation. I'll explain this. And by the way, neither have any of the other vendors you've heard about. Baron L. Stutzman of Arlene's Flowers in Oregon. If Jack Phillips were so discriminating, he would try to find out whether any customers walking through his door are gay. And he wouldn't sell them a cupcake. Wouldn't sell them anything. But that's not his practice. That's not his belief. Jack Phillips is not anti-anybody. He is pro-Christian. All he wants, without pushing his beliefs on anyone else, is to be able to insist on having his creative gifts under his control, not hijacked to produce artistic expressions that contradict his religious conscience. This is, by the way, the same reason Jack Phillips will not do anything related to Halloween, cakes with profanity on them, or cakes celebrating a divorce. I try to get my head around asking for a divorce cake, but can't manage it.
That's good.
My wife in the peanut gallery. However, the Colorado authorities and courts all the way up in the state system have not only concluded that Jack Phillips is discriminating, they have unbelievably ordered that he, A, create the custom wedding cakes on demand, B, report regularly to the state Human Rights Commission a record of every refusal he gives to any customer's request and the reason for his refusal, just so they can keep tabs on him, and C, re-educate his staff, which mostly consists of his own family members, that he was wrong to resist the state's demands. Well, faced with these rulings and impositions, Phillips has, for the time being, entirely given up the specialty wedding side, the custom wedding side of his business, which had accounted for 40% of his shop's revenue. That's a sacrifice. So this case is now on the docket of the Supreme Court. It's definitely a case to watch. It has not been scheduled for oral argument yet, but the briefs are pouring in, the legal briefs on either side. The outcome of this case will tell us a lot about the future of religious freedom for unknown numbers of Americans who are in situations similar to that of Jack Phillips, willing to serve all customers without discrimination regarding who they are, but determined to be faithful Christians or Jews or Muslims in their public and commercial interactions with their fellow citizens. If Jack Phillips loses his case, not only will his fellow wedding vendors be at risk wherever new forms of discrimination law come into place, the result could also threaten institutions such as the one we're standing in. You're sitting, I'm standing. Such as Catholic schools, I mean, where in some schools, teachers have been let go as a consequence of their having entered into same-sex marriage. They could be charged with discriminating. Ultimately, to give another example that was actually conceded by the Obama administration's lawyer in the same-sex marriage case, a loss for religious freedom in Jack Phillips's case could even threaten, down the road, the tax-exempt status of religious institutions, even houses of worship themselves, if they refuse to bend to the new definition of marriage in American law. Now, the key argument to watch on the other side, and I'm almost finished, is the tireless effort of same-sex marriage and LGBT rights advocates to convince their fellow Americans, all of us, that declining to participate in the celebration and recognition of a same-sex wedding is just like racial discrimination, that it's just like not serving an interracial marriage. But conscientious belief in the true reality of marriage as the conjugal union of a man and a woman has nothing in common with a belief in someone else's innate racial inferiority. Jim Crow, segregation, anti-miscegenation laws against interracial marriage were systems of subjugation intended to keep people down and assert white supremacy as a principle of social order. But the view that a marriage is between a man and a woman, and that it's about any children they generate, is not hate. It's not bigotry, and it makes no adverse judgment about someone else's worth or dignity or essential human rights. This is where we are, however, in a changing society where faithful witness to the truth of such things is getting harder all the time. We should be praying for God to enlighten the minds of the powerful, including at least 5 Supreme Court justices. But we can also obey God by organizing, by educating ourselves, by arguing persuasively and lovingly for the truth, and by bearing witness to the truth in the public square. The best way to keep our religious freedom is to exercise it at every opportunity. Thank you.